Okay, what's up? Welcome to Advanced Strategy. This is Kristen. I got a letter from a subscriber, Shane. He's in a bad position. He's in jail. He was running around out here talking about how he has the right to travel, doesn't need a license or registration, and apparently the cops who pulled him over didn't agree with him in the state of Missouri. There's a difference between an ordinary private individual using the roads testing 1 2 testing. Hey, welcome to Advanced Strategy. This is Kristen. And guess what? There's a difference between an ordinary private individual using the roads to travel and a driver using the roads as a place of business. The former is a common right, and the latter is subject to regulation. So is it a right to use the road, or is it a privilege to use the road? Well, one thing's for sure, you cannot convert a right into a privilege, and you darn sure cannot convert a right into a crime. How's that going to work? So here's what happened. The private individuals paid for the roads. Who paid for the roads? We did. Private individuals paid for the roads, and then a handful of industrious folks said, hey, we can use the roads to make money too. And the private individuals said, okay, that's okay. But if you end up harming one of the private individuals who paid for these roads in your hustle and bustle to make money, then that's not okay. So what they did is they hired the police to regulate traffic. Traffic applies to drivers for hire. A driver is an employee. The right of a citizen to travel upon the public highways by automobile is not a mere privilege which a city can prohibit or permit at will, but a common right. Thompson versus Smith. Now, so I have the right to travel, but not to conduct business on the roads. Well, you can trust and believe that the insurance companies out here know the difference and understand the difference between an automobile and a vehicle. Okay? An automobile is private property for private purposes, like traveling. A vehicle is a machine. It's operated for commercial purposes, like driving. Again, a driver is a title. It is a job. It is an employee. A driver is an employee, someone for hire, like an Uber, etc. It matters what words you use. Okay, it especially matters what words you allow other people to use when they describe your activities, and then they want to call them a crime. Okay, so the police are there to regulate traffic, which traffic relates to vehicles for hire. So how can the prosecutor prove that traveling in an automobile is illegal? It can't. So the vehicle code only applies to, guess what? Vehicles, commercial enterprises, transporting passengers or packages for payment. So probable cause did not exist in my mind at all, because unless you see a commercial license plate on my automobile, then you have no reason to suspect me of driving for commerce in a vehicle. This is not a vehicle. It's an automobile. No, I was not driving. I was just traveling in it, not operating anything. And this is how they have tricked you down all the way. Ask for whatever facts the district attorney has that those codes apply to you. You assume that they do. That's a problem. They demand you make a plea. Okay, well, I cannot plead to something if I don't know what I'm pleading to. You have to demand a copy of the sworn complaint or valid charging instrument against you. I cannot make a plea to a claim that I cannot see or understand. Since I don't see a valid charging instrument, then I presume that's because one does not exist. I will not plead to a non-existent claim. Here's what happens, though. There are no valid charges against you. They just make it seem as if it is so. And they make it seem so unpleasant and insurmountable for you to get you to take a deal. Make a plea bargain. Then they'll go ahead and decide what to actually charge you with based on what you just agreed to be charged with in the contract. Because if they can't get you to voluntarily agree to some charges, then they got nothing. No valid charges actually exist. It's a bluff. They're scaring you down to get your consent to the whole proceeding, because once you submit or accept a plea, you grant them jurisdiction. The first question you should have asked was, are you on your oath today, Judge? Do you have an oath of office officially registered with this courthouse today? Watch what happens. You will hear a pin drop. Either they do or they don't, and they must answer that question. Well, now you got them on the record with it. So watch them change up. Now if they violate your rights, they can be charged with treason. And they're not going to risk that for anybody. It's very important. They need to give you discovery. What have you got against me anyway? There was no arrest warrant issued based on probable cause. It was required. There was no examination done to establish probable cause or gain jurisdiction. It was required. The only real way they gain jurisdiction is when you don't challenge it. Your silence is acceptance. At trial, the judge will instruct you that you cannot bring up anything to the jury except for a couple dumb things. But there is no law that says that. You have to understand they will lie to you in the court. Okay? The judge and the prosecutor are in it together, and they have to trick you down. They have to break laws, and they have to lie. They will test you to see how much you know. If they can tell you don't know very much, then they will continue to act like what you're saying is ridiculous. You have to hold their hand through the laws and explain to them how they apply to you in your situation. And then, begrudgingly, they will admit that they understand. Where is the probable cause affidavit or sworn statement for the public record? Did anyone sign their name on the line saying that the facts were true and correct under penalty of perjury? Okay, then you need to do your affidavit of fact, because an unrebutted affidavit becomes a judgment in law and in court. So an affidavit is just a statement that says, I swear under penalty of perjury that the facts in this statement are correct and true under penalty of perjury. And if they don't rebut what you said in that document, then your document will stand as the judgment. If you want judgment, you got to bring it. So, and this is the one weakness that they have. They don't have very many weaknesses because it's their system and they set it up for themselves very well. But nobody wants to put their name on the line and sign that anything is true under penalty of perjury. So now you have to use that against them. They don't have very many weaknesses, and that's a big one. Motion to quash. Do it in the form of an affidavit. That means to throw out the charging instrument. So the State Motor Vehicle Code, again, applies exclusively to vehicles, not automobiles. Yes, it matters what words you use. Yes, you have been tricked into using words that don't apply to you. Correct the record. Now, you have to become proficient at asking questions. When they ask you, do you understand the charges against you? No, I do not. I have some questions regarding the nature and causes of the charges. Or I have some question regarding the nature of the claim. Is that okay, Judge? Now you've got him. Because now he has to answer all of your questions to your satisfaction before you proceed. Now you have a right to ask, and he has a duty to answer. Start with some simple things. Is this a civil or criminal matter? Okay, let the record show that the defendant is being charged for a criminal matter. If it's civil, then object and move for dismissal. You're in the wrong court. The state cannot do a civil case against you. It would be like the state is the prosecutor and the judge at the same time, and that's not fair. If it's criminal, great. Let the record show it's a criminal jurisdiction and that the defendant is being charged for a criminal matter. Now, there are only two criminal jurisdictions: common law criminal or admiralty criminal. If it's common law, then it's over for lack of an injured party. If it's admiralty, then there must be a contract. Now, since the rules and procedures for all these different jurisdictions are very different from each other, then do you have the right to know what jurisdiction they are operating under? Yes, you do. You need to know. It is admiralty, and the contract they're going on is the driver's license. Okay. Or is it a secret jurisdiction? Because they're going to tell you, the judge will say, well, go get a lawyer. He'll explain it to you. Okay, so let the record show that this court is operating under a secret jurisdiction that is known and understood only by licensed attorneys? Your Honor, does the admiralty jurisdiction require a valid contract to be in dispute? How am I compelled under it? Put it into evidence then. Again, these are things you need to know. Now, that would be a good time for you to reserve your right not to be held under any contract that you didn't enter into knowingly, willingly, and with full disclosure, which tosses out the driver's license, by the way. Let them know the driver's license was under duress, since they told you you had to have it, and you waive any benefits you supposedly got from it, which the only benefit you ever got from it was the ability to go to jail. So they're going to say, oh, that you violated a statute. Okay. The legal definition of the word violate means to harm. Where is the injured party? Did you harm a statute which is not alive? I don't think so. These are the rights that you have in court that they will try to cheat you out of. You have the right to be informed of the true nature and cause of the crime. You have the right to specifically reserve any and all of your rights. You have the right to remain silent, not to incriminate yourself. You have the right to say what you want and be heard. You have the right to represent yourself. You have the right to object to any statement made by the judge. You have the right to object to any statement made by the prosecutor. You have the right to recuse or dismiss the judge and get another one. You have the right to call witnesses to help your defense. You have the right to legal counsel. It doesn't have to be a licensed attorney. It can just be legal counsel. You have the right to submit motions, the right to a fair trial, the right to face the injured party claiming damages. Now, can you face the state of Missouri? No, they don't exist. It's a corporation. It's a dead legal entity. You have the right to protest and object if any of your rights or demands are not being met. Basically, the state cannot be harmed because it's dead. It's not alive. It's a legal fiction. It's not a living person. It's not a living man. You have the right to protest and object if any of your rights or demands are not being met. You have the right to demand that the court put into evidence any unrevealed contract, statute, law, rule, or information being used against you. You have the right to personal liberty. And by the way, your freedom is your property that they've taken from you. And you have the right to sue them for wrongful arrest and wrongful imprisonment and get paid for every single day you were in jail. Okay? They already know what time it is. They've seen too many of their fellow cops lose those lawsuits because, let me tell you something, go file your claim because they don't follow the law. So yes, they will lose those lawsuits all the time. I have a personal friend who won $75,000 for a wrongful arrest in California. And he didn't even have a good lawyer. He just had his friend Tom, who helped him with the court case, who did a great job. Thanks, Tom. Now, that's how you get them back for everything they did to you, by filing a counterclaim or a separate lawsuit. Do it now, and then you'll drop yours if they drop theirs. The end. Because if you were not doing anything wrong at the time, then they had no lawful reason to arrest you. How to win? By getting the judge or prosecutor to dismiss the case. Throw it out. A motion to dismiss can and should be done on paper and filed with the court, but you can make a motion to dismiss verbally in court anytime you want, anytime you see a reason why it should be dismissed. The battle will inevitably be a psychological one between you and the judge. Be prepared with your questions. Meditate on good questions to ask. Bait, steer, and corner. This is the main tactic to use to manipulate the judge to dismiss the case. The idea is to paint him into a corner where he has no legal basis to proceed against you. Remember, if A is like B and B is like C, then A is like C. Use logic and good questions and have backup questions ready. Know your motions. Motion to dismiss the case for one of many good reasons. Motion to declare a mistrial because of obvious error in procedure. Motion to prove jurisdiction. Motion for discovery to produce all evidence and information being used against you. Motion to make evidence. Someone needs to put missing information into evidence. Motion to recuse the judge for obvious bias or prejudice against you. Motion to find the prosecutor in contempt for rude behavior. Motion for fact-finding. That's what you need to do to get to the bottom of the words. It has come to my attention that the words that are being used against me are deceptive in the legal definitions of them. And we need to all get on the same page before we can move forward. So you need to ask the judge for a fact-finding or make a motion for finding a fact. Okay, motion for trial by jury of 12. Motion to subpoena witnesses. A motion to refuse the jury for cause because of impartiality or ignorance. A motion for continuance. Motion for retrial. The top priority is the motion to dismiss and the motion for retrial. Use them every chance you can. Valid reasons are lack of jurisdiction, unlawfully obtained evidence, failure of the officer to appear, lack of evidence, evidence of extreme bias to the defendant, failure of the court to uphold your constitutional rights, failure of the court to maintain a fair hearing. Objection, objection, objection. If the judge denies your motion, object and give your reason. If the judge makes any decision or ruling that you disagree with, object and give your reason. Every violation of your rights, every abuse of power, every threat to your well-being is an opportunity for you to record everything in your favor for dismissal or retrial. Here's the sequence of events. Arraignment is required. Special appearance. Plea bargain hearing is required. Motions hearing. Pretrial conference is required. Trial, sentencing, retrial motions hearing, appeals hearing. They only care about arraignment, plea, trial, and sentencing. Now, if it has been 6 months since the day of the citation, motion to dismiss. Send in a motion to dismiss with a notice of default stating that the court has already violated your Sixth Amendment right to a speedy trial, thereby voiding the case against you. Okay, so here's what happened. There is trickery in the words being used against you. And as you can see on screen, by the way, all ambiguities in the document are resolved in favor of the defendant. That's not me saying it. That's their rules to say it. Now, it's a 1-2 punch because they know that the masses don't understand the difference between traveling and driving. No, I wasn't driving. Let the record show it. Okay, but if somehow you figure that out, that there's a difference between traveling and driving, and by the way, the right to travel, the right to interstate travel is the very first right we ever had in this country, so it's very real. It's sacred. The right to travel by automobile, not the right to drive. No, you may not drive without a license. Don't ask anyone for that. That's foolishness. Driving has to be regulated. Traveling in your automobile is for private purposes. That's not their job to regulate that. Now, but they know that even if you figure out the difference between driving and traveling, they know that you don't know the difference between an automobile and a vehicle. So they'll get you there. Now, some of the remedies, bam, motion to dismiss. Argue that the failure to include the affidavit, they're not going to include it. It better be in there for their sake. An affidavit declaring probable cause. If it's not there, then the charges are defective under Rule 2209. The State versus Johnson let us know that probable cause affidavit is required for arrest warrants. And failure to document that can invalidate the proceedings. In Missouri, a motion to quash is typically used to challenge defects in the charging document. If successful, the court may dismiss the charges or require the prosecution to correct the defect. That's why you do your notice of abatement. You're not challenging jurisdiction. You're not challenging the court's authority. You're doing them a solid. You're giving them a chance, the prosecutor a chance to fix his errors so that he can get jurisdiction over you in that courtroom, so that that court has jurisdiction to hear the case or to make any judgment that can be legally binding on real people. Because the courts get their jurisdiction from one thing and one thing only: properly pled paperwork. And if the paperwork isn't perfect, and I mean perfect, then it doesn't have the legal authority to grant jurisdiction onto the court to hear the case, like I said, or to make any judgment that can be legally binding or affect real people. Now, again, also, specificity was required in the charging instrument. And nope, they don't have it. The terms are deceptive, and it says in their rules that if the defendant was misled, the proceedings are void. Okay? And yes, you absolutely were misled. You were definitely misled by the terminology, the deceptive terminology being used against you. So, but with all these errors, they can have all these errors in their paperwork all day long if they want to. But you have to prove that those errors prejudiced you or caused you harm. So you have to prove that you were prejudiced by those errors. That's just another way they slide things by the people. They say, oh yes, well, we had all these errors in our paperwork, sure, but you didn't say that you were harmed by it in any way, so it doesn't matter. So just know that in advance, that you will have to prove prejudice. Let them know that these errors and defects in their paperwork misled you into a false defense, because this misunderstanding could have been cleared up a long time ago. Okay? And you would have chosen a whole different line of argumentation and evidence if you understood the deceptive nature of the terminology that was being used against you. You would have cleared this up a long time ago. So you can file a motion to suppress evidence if it was obtained due to an unlawful arrest, which every arrest that is made without probable cause is an unlawful arrest. And guess what? That's all you need to get them on the false arrest, false imprisonment. Consult a lawyer. The purposes of this information is for research purposes only. For the purposes of doing more research, I do not give legal advice to anyone. But the habeas corpus petition should let them know that your confinement is illegal due to lack of probable cause. Legal basis for victory. False imprisonment, Missouri common law. These are some examples. The jury found that the detention lacked legal justification and violated Missouri tort laws. The court ruled that the city of St. Louis violated the Fourth Amendment rights by failing to conduct a timely probable cause hearing, by failure to train officers on proper post-arrest procedures. Municipal liability. Evidence showed a pattern of similar wrongful detentions in St. Louis jails, supporting deliberate indifference by the city. Key evidence that secured the win. The jail logs, proving that the suspect was held beyond the 48-hour limit for arraignment. That's all. If you held me for more than 48 hours, you already screwed up. And the police reports admitting misidentification error early in detection. In my opinion, they most certainly misidentified me. Do they have a copy of a printout from the Secretary of State for that state showing that I'm an incorporated charter? No? Then why are they spelling my name that way? Listen, the rules of grammar are very important. They went to school. They understand. I spell my name with capital K, lowercase R-I-S-T-E-N. Okay? A proper noun. Like I said, they went to school. You shouldn't just let those things slide by. Only the all caps can go to jail. Period. So, but the trend is that the Missouri courts are increasingly siding with plaintiffs when the detention exceeds the constitutional limits, which is only 48 hours. In the next video, I will talk about what you can do possibly to utilize the creditor process. First of all, you would get a copy of the document that appointed the public defender to your case. Don't call him a defender, call him an attorney. Because you're not going to defend anything, and he's not going to defend anything. Get that document, accept it for value, and return it to the attorney. Send it to him at his address where he works, and let him know that you have a letter of instruction, that you accept the court's offer. Don't dishonor the court, accept their offer. This is how you become creditor. It's through your acceptance. And then you can instruct the attorney of how he is to handle the case. And brothers and sisters, I will see you in the very next video, which I've already posted, so it's not a cliffhanger. Good luck, Shane. Stay strong. And remember, it's not personal. It's just business. Stay calm in court or you will lose. But I have a great hope for you that you will prevail in this case. Be sure to watch the next video for the creditor process. Take care. Stay strong.